In Plessy versus Ferguson, the court would uphold a notorious exercise of Louisiana's police power. In 1890, Louisiana required all trains to provide equal but separate accommodations for the white and colored races by providing 2 or more passenger coaches for each passenger train. On June 8, 1892, Homer Plessy intentionally took possession of a vacant seat in a coach where passengers of the white race were accommodated. The train conductor ordered Plessy, who was described by the court as of mixed descent, to take a seat in the other coach. Plessy refused and was forcibly ejected by a police officer. After his arrest, Plessy posted a $500 bond and was released. There are strong indications that this situation was manufactured to create a test case to challenge the validity of Jim Crow laws. Plessy filed suit against John H. Ferguson, the judge of the criminal court who handed down his sentence. The Supreme Court upheld Plessy's conviction by a vote of 8-1. Justice Henry Brown wrote the majority opinion. Like in the civil rights cases, Justice John Marshall Harlan was the lone dissenter. The majority opinion had 2 parts. First, the court rejected the argument that Louisiana's segregation law violated the 13th Amendment, a statute which implies merely a legal distinction between the white and colored races, the court found, has no tendency to destroy the legal equality of the 2 races or reestablish a state of involuntary servitude. The court explained that the underlying fallacy of the plaintiff's argument is the assumption that the enforced separation of the 2 races stamps the colored race with a badge of inferiority. Justice Brown observed, "If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it." Study guide. If racial separation did not stamp the colored race with a badge of inferiority, why did Louisiana favor it? Second, the court turned to the 14th Amendment. Justice Brown explained that laws permitting and even requiring their separation in places are within the exercise of the state's police power. Study guide. Compare the court's review of the state's police power in Yickwo and in Plessy. In Yickwo, Justice Brown contended, the court found the San Francisco Ordinance violated the 14th Amendment because it conferred upon the municipal authorities arbitrary power to deny laundry licenses. This ordinance was a covert attempt to make an arbitrary and unjust discrimination against the Chinese race. In Plessy, however, the court found that the case reduced itself to the question whether the statute of Louisiana is a reasonable regulation, and with respect to this, there must necessarily be a large discretion on the part of the legislature. Louisiana's segregation law was a reasonable exercise of the state's police power, in light of the established usages, customs, and traditions of the people, and with a view to the promotion of their comfort and the preservation of the public peace and good order. The Plessy court did not cite any evidence that would justify this exercise of the police power. Indeed, Justice Brown provided no factual basis to demonstrate that integrated railroad cars pose any problem to the public peace and the good order. Justice Brown added that the 14th Amendment was never intended to abolish distinctions based upon color or to enforce a commingling of the 2 races upon terms unsatisfactory to either. But the law did not enforce any commingling of the races. Instead, it was the ordinance that prevented people of different races from choosing to commingle. Finally, the court noted, the separation of the 2 races in public conveyances is no more obnoxious to the 14th Amendment than the acts of Congress requiring separate schools for colored children in the District of Columbia, the constitutionality of which does not seem to have been questioned. When we study Brown versus Board of Education, we will revisit Congress's decision to segregate schools in the Federal District of Columbia. Therefore, the court found that the Louisiana segregation law did not violate the 13th or the 14th Amendments. Once again, Justice Harlan was the lone dissenter. First, he observed that the arbitrary separation of citizens on the basis of race while they are on a public highway is a badge of servitude. Such a law cannot survive scrutiny under the 13th Amendment. Second, Justice Harlan turned to the 14th Amendment's Equal Protection Clause. He wrote that the Constitution does not permit any public authority to know the race of those entitled to be protected in the enjoyment of such rights. In a famous passage, Justice Harlan stated that our Constitution is colorblind and neither knows nor tolerates classes among citizens. In this country, he added, there is no superior, dominant ruling class of citizens, and in respect to civil rights, all citizens are equal before the law. Study guide. Can you see why modern Supreme Court justices may object to viewing the Constitution as a colorblind document? For example, can the government adopt race-conscious measures to help rather than to hurt racial minorities? Instead of trying to figure out the legislator's intent, Justice Harlan instead measured the fit between the end the government is trying to achieve and the means it is employing. He found that segregating train cars is not at all germane, that is related to an end to which the legislature was competent. Because this connection was not close enough, the segregation law was not a reasonable exercise of the police power. Justice Harlan believed that the police power of states was limited to ends to which a legislature is competent. This approach is reminiscent of Justice Chase's description of the legislative power in Calder v. Ball. Plessy continued the trend of other decisions that narrow the scope of the Reconstruction Amendments. Like Slaughterhouse, Cruikshank, and the civil rights cases before it, Plessy substantially weakened the 14th Amendment. While these latter three cases remain good law, Plessy is not. In his dissent, Justice Harlan predicted that Plessy would become as pernicious as Dred Scott v. Sanford. He was right. Today, Plessy versus Ferguson and Dred Scott are part of the anti-canon. More than a century later, Phoebe Ferguson and Keith Plessy, descendants of the litigants in the infamous case, founded the Plessy and Ferguson Foundation. The organization aims to teach the history of the case and explain why it is still relevant today.